Child pornography charges can come in an array of felony levels. Most commonly is the felony to pandering in the obscenities of a minor. Under this statute, it's punishable from 2 to 8 years, and the sex offender registration is a Tier 2 offense, which means 25 years of registration. That's non-negotiable if you're convicted of the offense. It requires in-person verification every 180 days. The F2, pandering in the obscenities of a minor, means that you distributed it, copied it, produced it, which means maybe you made the child pornography. It's the highest level of these child pornography related charges. The issue with this charge specifically is that prosecutors' offices around Ohio are charging people under this statute, and they shouldn't be, because our clients are not, technically speaking, redistributing it. And what I mean by that is this. These prosecutors are saying that because our client downloaded a file, they copied it. And by copying the file, you qualify under the F2 statute, where the actual statute they should potentially be charged with is an F4, which is just being in mere possession. I have fought this issue on a number of cases. I think I'm probably the only one that really argues it, but it's a common sense argument, and I think I've been effective with some judges treating clients more leniently, understanding that technically, yes, maybe this could qualify under the statute. But let's be real, when these laws were made, we didn't even have downloads. There were no share file programs. In today's day and age, you really can't view material unless you reproduce it or copy it. It's not really even possible. The argument could be made that by merely streaming it, you're reproducing it. You're copying it to your screen. And it's because the policy behind this law, when it was made, was meant to punish the people that were truly taking VHS tapes, recopying them, and having them distributed under the underground world of child pornography. That's why that statute's there, and that's why it exists. And that's not what the majority of our clients are doing, and that's what they're trying to accuse them of. And a lot of my job in some of these cases is distinguishing the difference between why my client should be treated as a possessor and not a distributor, which has far different penalties. The F2 is punishable from 2 to 8 years in prison, and there's a presumption that you be sent to prison on that. Without even any prior criminal history, the law states you're presumed to go to prison for that period. Where the F4, which is a mere possession, is punishable up to 18 months, and there's no presumption that you go to prison. That can oftentimes be the difference between going home or going to prison at the date of sentencing.